Friends, we are starting now. Today is 182nd Friday group meeting. Topic is IBC, Insolvency and Bankruptcy Code, the story so far and what lies ahead. The speaker is our beloved senior advocate, very young and promising advocate, Mr. Chinmoy Sharma, senior advocate. So immediately accepted. Interestingly, after Vishwanath's video, he followed that. He suggested for Insolvency and Bank, IBC. So immediately he approached me. I said, love to sir, and immediately we got the date. Thank you so much.
Thank you so much.
Before we start, I request Ms. Ruby, our youngest Friday group member, will read a few details of our Chinmoy Sharma. Ruby, take this one.
Good afternoon to all learned senior advocates and advocates. I have got an opportunity today to speak briefly about learned senior advocate Shri Chinmoy Sharma on this honorable court. He completed his high schooling from St. Columbus School from New Delhi. After completion of his schooling, he went to ILS Law College, Pune for law degree. He got enrolled in Bar Council of Delhi in the year 2002. At the very young age, he was designated senior advocate by Honorable Supreme Court of India in year 2021. Shri Chinmoy Sharma was groomed as a counsel under the tutelage age of former Attorney General Shri Ghulam E. Vahanvati, senior advocate. He is regarded as a meticulous, dependable and consistent in profession with his ability to think on feet and out of the box. He gave new wings to legal profession. Shri Chinmoy Sharma's ability, integrity, competence and hard work has been acknowledged and recognized by both bar and bench. Shri Chinmoy Sharma possesses expertise which includes commercial disputes relating to contracts, infrastructure projects, banking and finance, insurance, insolvency, intellectual property rights, direct and indirect taxation, media, telecom and power. Being a skilled civil and commercial counsel with special emphasis on arbitrations for the last decade, Shri Chinmoy Sharma is a member of several international and national bar associations and organizations such as Supreme Court Bar Association, International Bar Association, Chartered Institute of Arbitrators, Indian Chapter of International Chamber of Commerce and ICC's Young Arbitrators Forum. Legal profession is still looking forward to be enriched by his vast experience.
Thank you, Ruby. Thank you very much, Ruby.
Good afternoon, everyone. Thank you so much, Seshu sir, and thank you for the lovely, kind words. I am here to speak about the Insolvency Bankruptcy Code. As the name suggests, it is a code and not an act. Why is it a code? It is a code because pre-2016 there were several acts which were dealing with these issues and the laws relating to insolvency and bankruptcy. In 2016 there was a consolidation of provisions from the Companies Act, all the old insolvency acts, and then most importantly the Sikh Industrial Companies Act, which dealt with rehabilitation of companies. So in 2016 all this was consolidated and made into what is now known as the Insolvency and Bankruptcy Code. The primary objective is twofold. The first is insolvency resolution process, and then we go to what is called the liquidation process. So I will deal with it one by one. Before going into the nuances of the IBC, I would like to inform that the tribunal dealing with the IBC is, as everybody knows, the NCLT. The appellate forum is the NCLAT, and then of course appeals come to the Supreme Court. Now as far as the IBC is concerned, like I said, there are three aspects to it. One is the resolution process itself, the second is the liquidation, and the third aspect is what comes after that. Now, for the purposes of initiating proceedings under the IBC for what is called CIRP, and the short form, the full form is Corporate Insolvency Resolution Process. There are two parties that can file proceedings before the NCLT for initiation of this process. One is the operational creditor, and the second group is called the financial creditor. An operational creditor can initiate proceedings under the IBC under section 9 for what is called operational debt. Now, what is operational debt? Operational debt is debt arising out of any goods or services. Suppose you provide certain goods to a company for which some part of the debt is unpaid. You can file proceedings against that company. Or if services are provided, then in that case, for the services rendered, the payments which are defaulted, for that also you can approach the NCLT under section 9 of the IBC. There is a second part, which is the financial creditor. Now, what is a financial creditor? Primarily, financial creditors are banks and financial institutions which lend money in terms of loans, and for unpaid loans you can file proceedings under section 7 of the IBC. Earlier, the law was that even under the IBC, it has to be for time value of money, which means that there has to be an interest component to it. But the Supreme Court in Orator Marketing versus Samtech Designs has held now that for unsecured loans also, a person can file or initiate proceedings under section 7 as a financial creditor against a company. There is another aspect which is called voluntary. If you want to voluntarily initiate proceedings against yourself for the CIRP, which has been done in recently by GoAir, I'll come to that subsequently. But for now, I will deal with the aspect of generically how the process functions. As I said, you file a section 9 or a section 7 application before the NCLT, and then the process starts. The first stage is the admission stage, the pre-admission stage. In the pre-admission stage, when the petition is filed, the tribunal only needs to look at three things. One is whether it meets the threshold. Earlier the threshold was 1 lakh, then it was subsequently by an amendment made 1 crore. You have to also see whether there is a pre-existing dispute or not between the parties. It has been held that IBC is not a recovery mechanism. So if you have some monies outstanding against a particular company, you can take recourse to civil suit or arbitration depending on what your contract contains, and that is the recovery mechanism which is prescribed. When you choose to go under the IBC is very specifically for the resolution process. So you have to then give in to the jurisdiction and you have to follow the process of the CIR. It is a different matter that at several stages there are options to settle the dispute with the corporate debtor, and settlement is very vividly laid down, but it is not a recovery mechanism. So the first step is that the NCLT looks at the threshold first, sees whether there is a pre-existing dispute or not, and then goes on to appoint what is called an interim resolution professional, which is an IRP. What is an IRP? IRP is a professional who has to go through a process of examination by the board, and you have to affiliate yourself, and the resolution professional is normally a person who is either a CS or a lawyer, a chartered accountant. Primarily these are the three people who normally become IRPs. Once the process of admission starts and then it goes into the appointment of the IRP, it goes to what is called the COC. Now before that, when the default is more than 1 crore, the party can initiate how you have to first give a demand notice. The difference between an operational creditor and a financial creditor primarily is the route that a financial creditor and a operational creditor has to follow. If you are a financial creditor, it obviously means that since you are a provider of goods and services, you will have to issue what is called a demand notice. You initiate it with a demand notice. Now there are two forms which are prescribed, Form 3 and Form 4. What is the difference? The difference is that when in the usual course of business between the corporate debtor and the operational creditor, there are invoices raised, then you have to issue your notice under Form 4 by saying that this is the amount due and this is my invoice and I am demanding this amount, failing which you issue this notice under section 8, and then the subsequent is if the party does not pay, or if the party is unable to show that it has paid, that gives you a right to file your proceedings as an operational creditor. In contradistinction, financial creditor does not have to go through this route. A financial creditor, the moment the financial creditor takes a decision that I want to initiate corporate insolvency resolution process against a corporate debtor, it can go ahead and file the proceedings before the NCLT under section 7. Now, once the demand notice is issued and let's say it is not paid, you go into the CIRP resolution process, the IRP is then appointed, and then the process of corporate insolvency resolution process starts. What is the COC? COC is called the Committee of Creditors. It has been held by the Supreme Court that the COC is the decision-making body. For every decision, the COC is like the, if I could say it in layman's terms, it is like a board of directors of a company. So when a resolution professional is appointed, there is no board left in the company. So COC takes over as the board, and the resolution professional who is appointed by the NCLT may continue as the resolution professional subject to the approval of the COC. So if the COC says that yes, this is the person to continue, then that person continues as the resolution professional. Otherwise, the COC is free to choose or appoint a resolution professional, go to the NCLT and say, I want this person to become the resolution professional, and the NCLT then more often than not is always approving the resolution professional which is chosen by the COC. Now what does the RP do then? RP is like the CEO of the company now. The board of directors is the COC and the RP is the CEO. So all the decisions, financial decisions, are taken by the COC and put into effect by the resolution professional. It has been held in several judgments, I will just give the judgment subsequently, that the financial wisdom of the COC is paramount. It has been held in SR Steel now, totally it is beyond any reasonable doubt that the COC now has the supremacy in all decisions which are taken in a company which is the corporate debtor. The resolution professional then calls for claims from other people. Now when the one important aspect that happens in between is the moratorium part. What is a moratorium? The moment an order of admission is passed against a corporate debtor, under section 14 of the IBC, there is a moratorium. Moratorium means that any suit or proceedings against the corporate debtor comes to a standstill. Though of course, with the permission of the COC, the resolution professional can initiate claims on behalf of the corporate debtor, but against the corporate debtor, there is a full moratorium. No suits, no proceedings, no execution, everything comes to a standstill. And the reason behind that is that when the resolution professional calls for claims, it also considers the claims of several parties. Suppose there's an award against the corporate debtor, that will also form a part of the claim. Suppose there's a decree against the corporate debtor, that also will form a part of the claim. So all that is consolidated in what is called the claims form. You have to file a form C, which is your claim form, under which you say what you are claiming under what either you claim under invoices, or you claim under an award, or you claim under a decree. So whatever is your claim, you can put the claim before the resolution professional, and the resolution professional assesses those claims, carries out what is called the verification of the claims, and subsequently then the payments are to be made to these claimants depending on what claims are accepted, what are not. Then comes the stage of what is called the resolution plan. When a company goes into a CIRP, the objective is to ensure that the company is a going concern, and the going concern is run by the resolution professional till such time that a resolution applicant takes over through a resolution plan subsequently. So the idea behind the IBC is, in distinction to the Companies Act 1956 or let's say the Companies Act 2013, where when a company was unable to pay its debts, you had to go to the High Court and file what is called a petition for winding up. Winding up would be the death of the company. IBC, the epoch-making change that the IBC has brought about is that you are looking at revival of the company rather than the death of the company. So you are looking at trying to make sure that a resolution applicant brings in a resolution plan which will ensure that the company is going to run. Rather than being unable to pay debt, you directly take it to liquidation and then you pay off the claims and the company comes to an end. That is a subsequent stage. If the resolution does not go through, then liquidation follows. But at the first stage, you look at resolution. In the resolution stage, you call for resolution plans from resolution applicants. These resolution plans are assessed by the COC, and when the COC comes to a conclusion that a particular resolution plan is serving the interests of all the creditors, whether it is financial or it is operational, it serves the interests, the financial interests of everybody, and it takes care of a plan which is going to be useful for the running of the company post this process of corporate insolvency resolution. Though of course there have been a lot of heartburn amongst operational creditors because they actually stand on a slightly lower footing than the operational creditors, the financial creditors. Well, of course, now in Swiss ribbons, subsequently in SR Steel, it has been held that the distinction between an operational creditor and a financial creditor is well recognized by the IBC. So therefore, a financial creditor will always stand on a higher footing because the other financial creditors have actually lent out more money than an operational creditor. So the volumes are higher, so obviously the higher the charge or the higher the amount outstanding, the higher the right. It is as simple as that. So that has been laid to rest. Once the resolution plan is approved by the COC has to approve it by 66% of the shares. So 66% is the threshold. Suppose the debt owed to the financial institutions is, let's say, 100 crores. So all the financial institutions having 66 crore stakes or more can vote and say that we want this particular resolution plan to go through. So once the resolution plan is formulated and approved by the COC, it is then placed before the tribunal for approval. And as held by SR Steel, because SR Steel is the most landmark judgment that has come, Justice Nariman's judgment in the recent times on the issue of the CIRP, because it has laid to rest several niggling issues on the primacy of creditors, as far as who will take the decisions, how the process will move forward. So several aspects have been finally laid to rest. Now coming to the process of liquidation if the resolution process fails. As I pointed out, that liquidation is the last of it. The first effort is to revive, otherwise it is liquidation. And liquidation happens under two circumstances. One is if the resolution plan which is brought forth is not acceptable to the COC and they do not agree with it, or in another situation where sometimes it so happens that there are no resolution plans. Because what happens is when the company is in CIRP, it starts off as a going concern, and then subsequently somewhere down the line, because of certain delays which happen, it no longer remains a going concern, and sometimes it is not commercially viable for a resolution applicant to actually get into the running of the business, and the business fails. So in that event, there is no resolution plan in place. So the NCLT passes what is called a liquidation order. Now when the liquidation order is passed, the date of the liquidation order is called the liquidation commencement date. At the date, on that date, the liquidation commencement date is the date on which the COC then takes a form of a stakeholders coordination committee. and then the stakeholders coordination committee then steers the liquidation process, and the resolution professional, who was all throughout acting as a resolution professional, he becomes the liquidator. As in the earlier act, the 1956 act or the 2013 act, the liquidator is now the person who steps in and now takes over the entire, they takes charge of the complete assets of the company. There is a in section 29, there is just to rewind a little bit, since we were trying to complete that. In a resolution plan scenario, not everybody who wants to actually put in a resolution plan can do so, because there's a bar under section 29 where ex-promoters are barred. So it is like a backdoor entry is not permissible. Suppose a promoter director or some certain promoters of a company were not able to run the company and it ran into losses and was not able to pay its actual bills or invoices or to the financial creditors. So you are not allowed to then carry out a backdoor entry back into the company through a resolution plan. So there's a bar. The other bar is, let's say there's a willful defaulter who tries to step in as a resolution applicant. That is also not permissible. And more importantly, there are certain disqualifications which are there under the Companies Act and the SEBI. Those people are also not allowed to become resolution applicants. And the reason is very obvious, that you only want credible people to revive the company, to run the company, and people who have defaults or have failed to do what was required to do to run the company, they are not supposed to be given an entry into the company. Now, when we move into the liquidation process, on the liquidation commencement date, the assets of the company are consolidated. Again, a Form D is to be filed by the creditors to make the claim. Now there are two sets of, again, as we see, there are two sets of creditors. One is the operational creditor, the other is financial creditor. The operational creditor technically doesn't have too much of discretion. All they have to do is just file the claim before the liquidator. The financial creditor, who are banks and financial institutions, they have a secured debt. Now when you take a loan or when you take a financial assistance from a bank or a financial institution, you have to secure it by way of a security interest. A financial institution under section 52 has a discretion whether to give up its security and enter into the general pool of liquidation under the IBC, or you are then free to go under the SARFAC and enforce your security interest. If the financial creditor chooses to stay out of this liquidation process, they can do so, and that is permissible, and then they enforce it through other acts such as the SARFAC. But if you choose to relinquish, you can relinquish your security and say that I give myself to the liquidation process and I want to partake from the liquidation process that is being carried out by the liquidator. In that case, you relinquish the security and join the common pool. In the IBC, just like the Companies Act earlier, there is what is called a waterfall mechanism under section 53, very important, because it gives the hierarchy of claims. Whose claims are foremost, whose will be paid first, and then what follows. The hierarchy is like this generically. First comes the dues of the workman. Dues of the workman, for now it has been held that 24 months, the statute says that 24 months preceding the liquidation commencement date, the amount which is payable to the workman, the outstanding dues, will rank pari passu, which will be at par with the dues of the secured creditor. Then comes the other unsecured creditors or employees who are not workmen, who are merely employees, or workmen's dues after the 24 months period, they will all rank lower. And then comes the government dues also. Now there were a lot of litigations which have happened relating to whether there is primacy to the government dues. Let's say a company obviously in default will have income tax liability, excise liability, service tax liability. So whether they are superior to these claims, that has now been put to rest by the section itself, which now provides for the waterfall mechanism, and you go by the hierarchy which is mentioned in section 53. The assets of the company are then sold, and all the creditors or people who are involved in the liquidation process, they are paid according to the category. Now let's say workman's dues and the dues of the secured creditor comes first. So first they will be paid, and in a proportion which has been fixed. So proportionately it is also possible that operational creditors actually rank much lower. So in a liquidation scenario, the people who benefit the most and ideally should benefit the most are the workmen, of course, because they have put their blood and sweat into the company. The secured creditors take a large chunk of the cake because according to them and according to the intention of the code, they have given their loans to the company and have made sure that the company runs. Then the government dues, of course, need to be paid at a particular point of time, so they are also paid. But the operational creditors, unfortunately, in a liquidation scenario, they have to take what is called a big haircut. It is difficult, but that's how the system is, and that is why, in a practical sense, because in practical terms, when you go to the NCLT, you will see that most of the operational creditors want to settle the disputes before going into the admission stage, because once it goes to the admission stage, then the settlement can only take place with the full permission of the COC. The COC, 99% of the COC has to say that we agree to settle the debt with the operational creditor or with any other creditor. In a pre-admission stage, the corporate debtor and the operational creditor are free to enter into a settlement, and you can withdraw your petition under section 9 by putting a settlement in place. So mostly we have seen that operational creditors like to settle, because if it goes to the liquidation stage, then they have to, they are at the bottom. It's like the bottom of the food chain, so you're right at the bottom, so you do not get anything much. So you say that, okay, I will settle with the corporate debtor with whatever money is being offered. Normally the settlements take place. Now the process of liquidation ends when the assets, all the assets are then sold, and the claims in whatever proportion decided are settled by the liquidator in terms of a settlement plan which is drawn up, with the liquidation plan which is drawn up. And then the company actually then meet its corporate death, and the Ministry of Corporate Affairs and the Registrar of Companies is informed that this particular company went into liquidation, and then we have completed the process of liquidation, and this company should be struck out from the rolls of the MCA and the ROC. Now, there is another aspect in the IBC which is a subject matter of a lot of dispute, and the dispute is pending in the Supreme Court. Personal guarantors. Personal guarantors of a corporate debtor are also liable under the Companies Act in the process of CIRP. And the process is under a separate chapter, section 94 onwards, where the corporate debtor also can initiate the CIRP against the personal guarantor. So there are three people who can do it. One is the debtor, a creditor, and also a resolution professional appointed by the creditor or the debtor can initiate what is called personal insolvency against the guarantors. This particular process has been criticized because in a personal guarantee CIRP, the resolution professional has to give a report to the NCLT as to whether the personal guarantor's CIRP should take place or not. So the basis of the CIRP of a personal guarantor is actually a report of the resolution professional. And at the stage of preparation of this particular report, a debtor is not entitled to have any say. So that violates the principles of natural justice, and therefore these provisions have been challenged before this honorable court. Though of course, in certain NCLTs, I must say, are continuing the process of this personal insolvency, despite the fact that the Supreme Court is seized of the matter. But certain NCLTs are saying that because the matter is pending in this honorable court, therefore they are not proceeding. But the way I would look at it is that if the matter is pending in the Supreme Court, then ideally the NCLTs ought to hold their hands before taking a decision, because if tomorrow the Supreme Court takes a decision that these provisions are unconstitutional, then the situation will be that you cannot turn back the clock, because you have already carried out the CIRP, and in certain circumstances, depending on the when we know that certain matters take a bit of time, because there are batch of matters, there are about 150 odd petitions pending. So I would say that it is in the fitness of things that these provisions are kept in abeyance for now by the NCLT and looked into at a subsequent stage. Now there is one other method in which CIRP can be initiated, which I was saying earlier, under section 10, which is the voluntary CIRP process. Now, as all of you must be aware, GoAir was undergoing losses of crores and crores. They initiated the voluntary insolvency process under section 10. It's an interesting case in point, because this is the first time actually when the NCLT has actually admitted a petition under section 10. There was another attempt earlier by another company, but it did not go through. So this is the first example in India where voluntarily a company says to the NCLT that I am not in a position to pay my debts, so please restructure my company. And the objective is this. The objective is that once the company goes into a CIRP scenario, the financial institutions and the financial creditors get together and say that instead of 100 crores, I am willing to take 80 crores. So it is a restructuring process. Under the old SICA, which is the Sikh Industrial Companies Act, there also used to be a resolution process under the BIFR and the BIFR and IFR. BIFR was like the tribunal and the IFR was the appellate authority. But that particular way of restructuring did not work because of several red tapeism scenarios, and then the act itself, SICA itself, was not a very well drafted legislation. So therefore, most of the companies, by the time the company would go forward in the process through the act, by then the company would no longer remain a going concern, and perforce you would have to go to the company's court for winding up. But here, GoAir is a very good example, because GoAir realizes that by going into this particular CIRP scenario, there will obviously be a settlement and they will obviously be able to revive the company. That is the thinking which is on. But that particular case also, everybody started using the mechanism to file cases against corporate debtors. But in a voluntary winding up scenario, for the first time, the section is being tested and the provisions are being tested in a scenario where the company voluntarily goes for the insolvency resolution process. The first issue is, what is going to be the date on which the resolution admission is to take place, whether it is the date of filing or it is the date on which the order is passed. Now there is a little bit of confusion, because the lessors of the aircrafts, according to them, they say that the date on which the order was passed should be the effective date, because under the IBC that is the effective date. But according to GoAir, they say that because people knew that there is going to be this voluntary winding up scenario, so therefore everybody started cancelling their leases, the aircraft leases. The problem with the CIRP scenario where there is no asset left is that there will be no resolution plan, because the assets of the company are what is its gold mine. So unless and until you have some assets, no resolution professional will be able to deal with those, and no resolution applicant will be able to bring a complete resolution or bring about a resolution plan which will ensure that the company is revived and run. So therefore, it remains to be seen now how this provision is going to be taken forward and how things are going to evolve. There are certain chapters in the IBC which have not been notified till now. I'm sure you must have seen an IBC is a very thickish book. So what I'm saying right now in this span of 45 minutes is a very short part of it. There are several other things. One is what is called a pre-packaged insolvency resolution process. Now what is that? For MSMEs, for micro, small and medium enterprises, there is a scenario which is envisaged by the IBC, which has not been notified till now, which is going to be probably in the future, we will see that coming through. A resolution process for these MSMEs. Now, how different is it from the insolvency resolution process of, let's say, another company who is not an MSME is that when the corporate resolution, when the CIP starts, the company will continue to remain in charge of the business of operations, whereas when the CIRP process is initiated under section 9 for other companies, then it is the resolution professional and the COC that takes over. So because it is an MSME, it is a special provision which will ensure that the company itself will, rather the management of the company itself will run the company till such time that the resolution process is carried out. So that is one part. The other and more important part is what is called the insolvency resolution process for partnership firms and proprietorships. Now what we see is the IBC right now is only pertaining or governing insolvency process for companies. At a later date, maybe in the future, we will see that partnership firms and proprietorship firms will also be brought into the fold of this entire process, and the situation will be taken forward in partnership firms as well as proprietorship firms. Now that is how this entire structure of the IBC works. Now I have given examples of what has happened in the past and how it is going on at present. In future, the 2 or 3 aspects which I feel require certain reconsideration, or it requires some cases are of course pending in this court and other high courts. One issue of course is the what I said is under section 94, personal guarantors issue. That's one issue which is pending, that needs to be resolved. And the second is the section 10 scenario which I said, that also needs a bit of understanding, and then I'm sure cases will land up at the doorstep of this court for understanding as to how voluntary CIRP process will function. There are 2 or 3 aspects which also require I think judgment from this court, where there are judgments of NCLT and NCLAT on the issue, but no judgment of the Supreme Court. One is regarding the demand notice which is issued by an operational creditor. Now, as I said, there are 2 options which are available, Form 3 and Form 4. The confusion that arises is, if you see Form 3, a Form 3 is a comprehensive form where you have to give in the date of the default, you have to give in the amount of default, you have to say under what you are claiming. Form 4 is a very simple form which is like a covering letter and saying that this is the invoice on which I am claiming. Now, in Neeraj Jain case, the NCLT has held that if you raise invoices as in the ordinary course of business with the corporate debtor, then you must issue the Form 4 notice. You have no discretion available to you. If you have an invoice on which you are claiming, you issue a Form 4 notice. But the way the Form 3 and Form 4, the way it is structured, according to me, Form 3 is an essential component, because actual form is Form 3. But for some reason, Form 4 has taken precedence on invoices, because the invoice will only contain the amount, the date, the operative date on which you are claiming, and if there are more than 1 invoices, for 1 invoice, Form 3 would be sufficient, because you say that this is the amount from this period to this period. But let's say you have 10 invoices. How do you make the claim? So Form 3 has a particular slot where you can put in all the invoices under which you claim. So according to me, there needs to be a reconciliation as to when a Form 3 and a Form 4 can be issued. The other aspect is the discretion, whether it is a discretion which is available to the operational creditor, because now the law is that there is no discretion. You have to issue a Form 4. But the Form 4, according to me, is not a complete form. Form 3 is actually the complete form. So therefore, that needs to be reconciled. And one important aspect which is to be dealt with is the timeline for completing this CIRP. Under the Act, it is 180 days, and you can stretch it to 330 days. That's the maximum. In SR Steel's case, this court has said that 330 days is actually directory and not mandatory. But the NCLTs across the country, and I have also had personal experience of it, once you cross the threshold of the 330 days, they say that we have no discretion left, because according to IBC, it is, the way it is to be read is actually mandatory, because it says that you cannot go beyond 330 days. NCLT cannot extend the CIRP process beyond 330 days. So the date on which the order of admission of the petition is passed, from then counting towards the to the resolution plan approval is a chunk of 330 days, where the litigation process also, whether it's a litigation process or anything else, is to be under the provision itself, is to be a self-contained. You have to finish it within 330 days. There is no discretion. So therefore, NCLTs are saying that there is no discretion, therefore we are going to pass the liquidation order. But if you read SR Steel's judgment, SR Steel clearly says, this court has clearly said that it is only directory and not mandatory. So that needs to be reconciled, because if it is only directory and not mandatory, then all the orders for liquidation which are being passed by the tribunal, one day will obviously, the law might change, and then people might say that, oh, we didn't know, but we completed the 330 days, so therefore we went into liquidation. Which, and IBC is an evolving subject, because as I said earlier, only interest-free loans were not a part of the IBC. Only interest-bearing loans could form the subject matter of financial debt. But now Supreme Court has taken a different view. Supreme Court has said that even interest-free loans given by an entity will constitute a financial debt. So the law changes. So therefore, I think we need the Supreme Court to look into this aspect, and hopefully one day these clarifications will come through, because it is an important timeline. Because if 330 days is directory and not mandatory, then the tribunals have to give the resolution process a little more time, because sometimes time is really of the essence, because for whatever reasons, because resolution plans are being debated by the COC, or changes are being made to the resolution plans, or there are certain times when the COC wants certain changes to the resolution plan. It takes time. These are time consuming things, and in our country, things go according to its own pace. So we need that particular play in the joints. So hopefully these aspects will be clarified in the times to come by this court. But as of now, the IBC as it stands is, according to me, the law has primarily been laid down for most of the aspects, but then certain lacunas are obviously there, and that is why the courts are there to fill in those lacunas. And I'm hopeful that as time goes along, we will also learn more, and we will also get to contribute. And before I conclude, I thank everyone for being here, and thank you so much for sparing time. Thank you so much.
Thank you very much, Chinmoy ji. You are crystal clear on IBC, the way simplified, and several examples you have given, creditors and other things, particularly Goyer example directly come in its summon. So before that, I request Rahul Sharma give a vote of thanks. Yes, sir. After this question answers, any this summon.
Sir, it's an honor to have you here today as a speaker in Friday group. So you talked about IBC and the epoch-making change from Company Law 1956 and Company Law 2013 to the IBC Code of 2016. IBC 2016. So you talked about IRP and resolution mechanisms provided under IPC 2016. So you talked about NCLT, NCLAT and the appeal in the Honorable Supreme Court. So you talked about the Swiss Ribbons case, which clearly differentiate between the roles of operation creditors and financial creditors, and the preference is given to financial creditors under this IBC 2016. So, and you talked about the IRP, Committee of Creditors, COC, official liquidators appointed by Honorable High Courts and tribunals, and resolution plans, and how IBC has transformed the company law in India very well. Thank you, sir. Thank you for enlightening us. Thank you, G.Seshagiri Rao, sir, for organizing this lecture, and the members of the Friday group. Thank you.
Now, question answers. Anybody, please remove that.
This is actually better. The question answers are always better, because then I also will be tested.
Want anybody? Please raise your hand. Then you want? Please. Yeah, you just not this.
Sir, IBC is the one law which I see that there are a lot of amendments going on. It was earlier a small act, but now we see it is thicker than CPC. So do you think it will become more thicker in the times to come?
It is better that legislation becomes thicker and things are clarified, rather than lacunas being there where the courts are required to step in every time. So it is better that the legislature understands that there are lacunas and fills them, rather than the matters coming to court where the litigant has to every time come to the court to seek a clarification. So I feel that amendments are better than the litigants having to come to court. It is better that the legislature understands the lacuna and fills them.
We should also update accordingly, because each and every day, if
Yes.
the amendments are coming from the parliament, we have to update also.
Actually, the thing is, there are two acts today which are undergoing amendments on a repeated basis. One is the Arbitration Act.
Yes.
The second is the IBC. And the reason is very simple. The entire focus on commercial litigation today is arbitration, because arbitration is the future. Though, of course, earlier what used to happen is that arbitrations used to be long drawn, and the mindset was that arbitrations take a very long time. But because of the amendments, because of the amendments which have taken place, 2019, 21, as of 22 amendments have come, so it has become a more robust mechanism. So IBC also similarly, because of the amendments now, I think will become more and more robust. Because once you know that a mechanism provided for in the IBC, you can have faith in it. So more and more people will utilize that.
Sir, one more question. IBC also requires that a team of lawyers is for handling all those cases. A single lawyer cannot handle it, sir.
I wouldn't say so. Yes, there are several NCLTs spread all over the country, that is correct. But there are two sides to the coin. Now, some people say that the company court in the high courts were equipped enough to handle the scenario, and there was no need to create this another entity which is called the NCLT. Though, of course, the reason why NCLT was created, because there are technical members also who are supposedly experts of their subject and will be able to take care of those finer nuances of commercial law or the IBC better. But here lies the vicious cycle. You may say that there are several tribunals all over the country, it's difficult, you are saying that a team of lawyers is required. But the way I would look at it is that it gives an opportunity to lawyers, more lawyers and junior lawyers.
Yes.
I see, and it is very heartening to see that the NCLT is now, more and more junior lawyers are appearing.
Yes.
Because obviously senior lawyers are busy in the High Court or the Supreme Court, so junior lawyers are going to the tribunal. So it's becoming a good learning ground, and I've seen very good lawyers come up in the NCLT today. So in a way it is it is a heartening exercise.
Who is Srivastav, please.
What is the status of unsecured creditor and shareholder under new law?
Yes, they actually do. I agree that they fall much lower in the waterfall mechanism, but that's how it is, and it has been put to rest now. The Supreme Court in SR has said that in Swiss Ribbons case, the Supreme Court has said that the waterfall mechanism is how it is. And though of course it is, as my friend points out, that it is onerous on the unsecured creditors, but that's how it is. Though one aspect I must point out in the question answer session, home buyers for example, now by way of the pioneer judgment, home buyers have been made financial creditors. So hopefully maybe as we are pointing out that there may be amendments in the future to take care of unsecured creditors' interests also. So as we go along, as we learn along, maybe things might change. Today the law is this, but tomorrow the law may be something different.
What about shareholders?
Shareholders also, they fall in the same category as unsecured creditors.
Want to ask? Yeah, please. Yes. No? Yeah. Anyone further?
Because I've never been.
No, matters are not referred to mediation, though of course what happens is when the corporate debtor and the operational creditor or the financial creditor agree that there can be a settlement, then before the admission stage, you are entitled to carry out your own, in a private space, your own settlement process. Though of course not under a mediation scenario. No, there is no, in commercial litigation, now before you go to the court to initiate proceedings in a commercial dispute, there is a requirement for mediation, but that is not there in the NCLT. Only when you go to the NCLT and you file a petition, normally what happens, what I've seen is that the operational creditor and the corporate debtor do try to come into some sort of a settlement, and which is acceptable mechanism under the IBC also.
So they are going to file an agreement to the settlement.
Yes. Yeah, if there is settlement, private settlement, and you can go to the NCLT and say that we have entered into a settlement, on that basis, it's always withdrawn. You can withdraw the petition.
So I think, any questions? Thank you very much, sir. Thank you very much, friends. Kindly join for a cup of tea, please, in the canteen.
Thank you very much. Thank you.
Sir, we'll